The fourth unit is state responsibility. So under this, we will study about what is state responsibility under international law, what are the elements which constitutes a state to be responsible for any wrongful act, and what are the remedies given under the international law. And also we will study about few of the cases that have held some state responsible for its wrongful actions. State responsibility under international law. So the meaning is the accountability. Every state is accountable for its own conduct. So here we are talking about wrongful acts or omission. So if any state is involved in committing any wrongful act or omission, then under international law they will be held liable. So there are three elements which makes a state responsible for any wrongful omission or conduct. So first is attribution of conduct, second is breach of an international obligation, and the third one is the absence of precluding wrongfulness. तो precluding मतलब होता है prevent करना. तो first है अगर इन्वॉल्व है रॉन्गफुल एक्ट के कंडक्ट में, देन द स्टेट विल बी रिस्पॉन्सिबल. सेकेंड, अगर कोई ब्रीच हो रहा है, कोई इंटरनेशनल ऑब्लिगेशन है स्टेट के ऊपर जिसको फुलफिल करना है, बट स्टेट इज वायलेटिंग इट और ब्रीचिंग इट, तब भी स्टेट रिस्पॉन्सिबल होगा. थर्ड, कि कोई रॉन्गफुल एक्ट प्रिवेंट हो सकता था बट स्टेट डिड नॉट टेक एनी इफेक्ट. सो यहाँ पे जो ओमिशन है दैट विल ऑल्सो held state liable for the wrongful act. Next, so let's start with the attribution of conduct. So under this there are three headings. So state organs, any organ which comes under the state like executive, legislature or judiciary, if they are involved in committing some wrongful act at international level, damaging any international organization or state, then the entire state will be held responsible. And this fundamental principle was given in the Corfu Channel case. इसमें क्या हुआ था, अल्बेनिया के जो ओशन वाटर थे उसमें माइंस थे, and Albania did not prevent the British ship from entering the water, and because of that, because of the mines, the British ship suffered massive damages. So ICJ held Albania responsible for the damages that has been caused to the UK, because Albania को inform करना चाहिए था और वहां से mines remove करना चाहिए था. नेक्स्ट इज एंटिटीज एक्सरसाइजिंग गवर्नमेंटल अथॉरिटी. तो कोई भी एंटिटी, कॉरपोरेशन, कंपनी या ऑर्गेनाइजेशन अगर वो गवर्नमेंट अथॉरिटी के थ्रू एक्सरसाइज कर रही है या फिर पावर है उसके पास टू एक्ट एज अ गवर्नमेंटल अथॉरिटी, तो अगर वो लोग भी wrongful एक्ट में इन्वॉल्व होते हैं, देन ऑल्सो दे विल बी, द एंटायर स्टेट विल बी हेल्ड रिस्पॉन्सिबल. सो एंटिटीज एक्सरसाइजिंग गवर्नमेंटल अथॉरिटी. नेक्स्ट इज नॉन स्टेट एक्टर्स. इसमें होते हैं प्राइवेट इंडिविजुअल्स जो गवर्नमेंट के डायरेक्शन और कंट्रोल में होते हैं, जैसे कोई ऑफिसर है या फिर कोई भी एम्बेसडर हो गया, कोई एजेंट हो गया. इफ दे आर एक्टिंग on behalf of the government or under the direction of the government, and if they commit some wrongful act, then entire state will be responsible. और ये इसका लाइव एग्जांपल है निकारागुआ केस, जिसमें यूएस को आईसीजे रिस्पॉन्सिबल बोला था कि दैट यू आर रिस्पॉन्सिबल बिकॉज द कॉन्ट्रा रेबल्स दैट एंटर्ड द निकारागुआ एंड कॉज्ड सो मच डैमेज टू द कंट्री was under your effective control. So they will come under non-active states and US will be responsible because they attributed to the wrongful act. So second point is breach of an international obligation. तो अगर कोई भी स्टेट जिसके ऊपर कोई इंटरनेशनल ऑब्लिगेशन है कुछ करने की या नहीं करने की, अगर उसको ब्रीच करते हैं, वायलेट करते हैं, then also the state will be responsible under international law. So a state is responsible when it breaches an international obligation, whether arising from treaties, customary international law or any other sources of international law. अब इसका key consideration क्या होता है, that there should be an obligation. अब ऐसा नहीं होना चाहिए कि international law है but state के ऊपर obligation नहीं है, but still they have conducted it, so we are holding this state responsible. So the presence of obligation on a particular state is necessary. Second is, अब obligation है और उसका violation हो रहा है, then in that case this breach of an international obligation will be applicable स्टेट विल बी हेल्ड रिस्पॉन्सिबल। तो पहला क्या है, ऑब्लिगेशन होना चाहिए कि ऐसा करना है या नहीं करना है, और दूसरा है उस ऑब्लिगेशन को वायलेट करना, नहीं परफॉर्म करना या परफॉर्म करना। और इसका एग्जाम्पल है हम लोगों के पास यूनाइटेड स्टेट्स वर्सेस ईरान में। इस केस में क्या हुआ था, जो ईरान में यूएस की एक एम्बेसी थी उसको ईरानियन गवर्नमेंट फेल हुए थे प्रोटेक्ट करने में, एंड दैट एम्बेसी वाज डिस्ट्रॉयड बाय द रेबल ग्रुप्स। सो अंडर दिस the Iran has an obligation to protect the embassy of US, and they violated the obligation by failure to not protect the embassy. Now comes the third point, that is circumstances precluding wrongfulness. तो ऐसे circumstances जहाँ पे wrongfulness prevent हो सकता है, ठीक है। तो इसमें है कि अगर कंसेंट है, जैसे फॉर एग्जाम्पल वी आर टेकिंग यूएस एंड ईरान, तो अगर यूएस कंसेंट देता है कि ओके वी आर गिविंग यू फ्री पास टू नॉट परफॉर्म योर ऑब्लिगेशन, तो अगर कंसेंट है उस कंट्री का तो यहाँ पर ईरान के ऊपर स्टेट रिस्पॉन्सिबिलिटी नहीं आएगी। तो कंसेंट ऑफ द स्टेट अगेंस्ट whom the wrongful act has been done. सेकेंड इज सेल्फ डिफेंस, अगर कोई कंट्री सेल्फ डिफेंस में करता है तो यूनाइटेड नेशंस चार्टर उसको प्रोटेक्ट करता है कि अंडर सेल्फ डिफेंस यू कैन डू सच थिंग्स। नेक्स्ट इज फोर्स मेजर, मतलब कुछ ऐसा अनफोर्सिन इवेंट हो गया या ऐसा सर्कमस्टांसेस आ गया जिससे कोई कंट्री है वो अपना ऑब्लिगेशन नहीं फुलफिल कर पाई। यूएस एंड ईरान का ही एग्जाम्पल लेते हैं, जैसे ईरान में अगर वॉर स्टार्ट हो गया and Iranian government is not able to protect themselves from the rebel group, then how can they expect to protect the US embassy that was in Iran? So this is the example of force majeure. Next is distress, कोई ऐसा एक्शन कोई कंट्री लेती है जो इतने डिस्ट्रेस में लिया गया है टू सेव लाइव्स, अगर उनको लगता है कि इस एक्शन से कुछ लाइफ सेव हो सकते हैं, देन ऑल्सो इट विल फॉल अंडर द प्रिक्लूडिंग रॉन्गफुलनेस, मतलब प्रिवेंटिंग रॉन्गफुलनेस। एंड द लास्ट वन इज नेसेसिटी, मतलब ये ऐसा एक्शन करना नेसेसिटी था टू प्रिवेंट द grave danger or prevent the grave situation, then also the state will not be held liable. So first point or the first element under the state responsibility is the attribution to conduct, second is breach of an international obligation, and third one is circumstances where wrongfulness precluding wrongfulness can help the state for not being held liable. रेपरेशंस, सो रेपरेशंस का सिंपल मीनिंग होता है टू मेक अमेंड्स, अगर गलती हो गई है तो उसको कैसे इम्प्रूव किया जाए और कैसे उसको अमेंड किया जाए, सो दैट इज रेपरेशन। सो अंडर स्टेट रिस्पॉन्सिबिलिटी ऑफ इंटरनेशनल लॉ देर आर 3 टाइप्स ऑफ रेपरेशन दैट अ स्टेट कैन डू to amend their wrongful act. So first is restitution, that is restoring the situation to its pre-violation state. जैसे अगर कोई डैमेज हुआ है, जैसे यूएस और ईरान में एम्बेसी यूएस की जो ईरान में थी वो डिस्ट्रॉय हो गई है, तो अगर रेपरेशन करना है और ईरान रेस्टिट्यूशन ऑप्ट करता है या उसको ऊपर इम्पोज किया जाता है, देन इट विल बी द ऑब्लिगेशन ऑफ ईरान टू reconstruct the embassy and make it to a state which was before the violation of the obligation. Next is compensation, financial payment for damages caused. तो ईरान पैसा भी दे सकता है that okay we are not able to construct it again but we can pay for the financial damage that you have suffered because of our failure to follow the obligation. नेक्स्ट इज सेटिस्फैक्शन, अब इसमें क्या होता है, ईरान एक्नॉलेज करेगा कि हाँ वी हैव मेड अ मिस्टेक, वी आर सॉरी फॉर दैट, वी आर अपोलोजाइजिंग फॉर दैट, एंड वी गिव यू रीअश्योरेंस दैट इट विल नॉट बी रिपीटेड, कि आप फिर से अपना एम्बेसी बनाओ या कुछ भी फॉरेन रिलेशंस हमारे साथ रखो, वी आर गिविंग यू अश्योरेंस कि अब ऐसा दोबारा नहीं होगा, वी विल नॉट फेल टू comply with the obligation. So these are 3 reparations given under state responsibility of international law. So let's look at the cases where reparations has been used. So first one is Corfu Channel case. इसमें यूके वर्सेस अल्बेनिया था, वी नो दिस, वी हैव ऑलरेडी डिस्कस्ड इट इन द प्रीवियस स्लाइड. सो under this the principle of due diligence and the responsibility of states for actions within their territory that harm others has been established. मतलब इसमें ड्यू डिलिजेंस और स्टेट रिस्पॉन्सिबिलिटी का वो प्रिंसिपल एस्टैब्लिश हुआ था. एंड नेक्स्ट केस इज यूनाइटेड स्टेट्स वर्सेस ईरान. इसमें जो इसमें बोला गया था कि ईरान शुड not violate diplomatic missions, and it is the responsibility of the host state to protect the foreign nationals and also diplomatic missions. नेक्स्ट इज निकारागुआ केस, और इसमें क्या हुआ था, इसमें बोला गया था कि प्रिंसिपल ऑफ नॉन इंटरवेंशन एंड प्रोहिबिशन ऑफ द यूज ऑफ फोर्स शुड बी देयर, मतलब एक दूसरे के स्टेट में जाकर हम लोग इंटरफेयर नहीं कर सकते, इंटरवीन नहीं कर सकते और force nahi use karte, like weapons and all we cannot use that. So these are three cases. These cases have already been discussed in previous slides, so you can take reference from that also. So these cases are examples of amends, how the different states, the states that have committed wrongful conduct have made amends. Under international law, there are various theories which have different perspective on how and why states should be held responsible under international law. So such theories are, first is damage theory. This theory talks about the wrongful act which causes actual damage to another state or its national. So if there is a physical damage or injury to any other state or any foreign national, then only the state will be held responsible. तो इसका एलिमेंट क्या है, की एलिमेंट एक्चुअल अकरेंस होना चाहिए डैमेज का, और जो रॉन्गफुल एक्ट है उससे डायरेक्ट लिंक होना चाहिए कि बिकॉज ऑफ द wrongful act of this state, the state B has suffered, there should be a direct link. इसका एग्जाम्पल है कॉर्फू चैनल केस 1949. तो इसमें क्या हुआ था, जो अल्बेनियन वाटर थे उसमें माइंस थे, एंड अल्बेनिया वाज नॉट एबल टू इन्फॉर्म द ब्रिटिश वॉरशिप्स अबाउट द माइंस, and they were also unable to remove those mines. Because of that, the British warships suffered immense damages. Since the damage has been caused, so under the damage theory, Albania should be held responsible. So this is the damage theory that the international responsibility is talking about. Simple words में, अगर wrongful act से damage हुआ है, then only state will be responsible, otherwise not. Second theory is fault theory. जिसकी भी गलती है उसको responsible hold करेंगे. So here the intent और culpability of the state in committing the wrongful act matters. Intention क्या था, negligence था, recklessness था, ये सारी चीजों पे फोकस रहता है कि किसकी गलती थी. Even if it is because of negligence, the state will be held liable. फॉल्ट थ्योरी का की एलिमेंट क्या होता है, कल्पेबिलिटी, मतलब इंटेंशन क्या था, तो वो इंटेंशन देखना पड़ता है, जैसे नेग्लिजेंस था या इंटेंशनली रॉन्ग डूइंग था स्टेट का, सो दैट विल डिसाइड दी वेदर स्टेट विल बी हेल्ड रिस्पॉन्सिबल और नॉट. नेक्स्ट इज जो स्टैंडर्ड ऑफ कंडक्ट होता है, जो कोई भी एक प्रूडेंट स्टेट या कोई भी अपने साउंड माइंड में करेगा, वो अगर फेल होता है एक स्टैंडर्ड मेंटेन करने में, देन स्टेट विल बी रिस्पॉन्सिबल. सो एग्जांपल इज यूएस वर्सेस ईरान. इसमें वही हुआ था, ईरान वाज अनेबल टू प्रोटेक्ट द एम्बेसी एंड ईरान वाज अंडर द इंटरनेशनल ऑब्लिगेशन टू प्रोटेक्ट द फॉरेन एम्बेसीज इन द कंट्री. So here under the fault theory, Iran should be held responsible. Next comes the absolute liability and risk theory. This is the last theory, and under this there is no question of fault or damage. It says that the state will be entirely responsible for wrongful act whether there is fault or damage. So this idea says that if any activities that is so hazardous and so dangerous and state is involved in such activities, then it should be held responsible, doesn't matter fault is there or damage has been caused or not. So the key elements are certain activities like nuclear testing, industrial operations are recognized as posing significant risk. तो अगर ऐसा कुछ हो रहा है, किसी के न्यूक्लियर टेस्ट से, कोई इंडस्ट्रियल ऑपरेशन से किसी स्टेट को डैमेज होता है या उससे कोई भी other repercussions होता है, then also the state should be held responsible. Absolutely liable होना. Next is liability without fault. Fault है या नहीं है, irrespective of the matter, the state will be held responsible since it is absolute liability. तो इसका example है ट्रायल स्मेल्टर आर्बिट्रेशन यूएस वर्सेस कनाडा. इसमें कनाडा वाज हेल्ड रिस्पॉन्सिबल because it violated it caused pollution to the United Nations air because it was undergoing an industrial operation of smelting. Smelting एक process होता है metal extract करने का, तो वो metal extraction जब हो रहा था कनाडा में, because of that US suffered air pollution. So under this the Canada should be held responsible because carrying out such activity poses a serious threat. So it is one of the significant cases under state responsibility. La Grande case is famously known as La Grande case. So this case is between Germany and USA. It was filed before the ICJ in the year 2001. So under this case, what happened? There were two German nationals, Karl and Walter Lagrande, and they were convicted of murder in US, and the US sentenced them to death. But here the US authorities failed to inform Karl and Walter about their right to consular assistance, which is a mandatory clause under Article 36 of the Vienna Convention. Now let's understand what is right to consular assistance. So in every state there are embassies, and there is a body, consulate, and consulate helps the foreign nationals with their legal proceedings and process. So here the United States failed to inform Walter and Karl about their right to consular assistance. मतलब वो consulate में help ले सकते थे, assistance ले सकते थे regarding their legal matter. And also this right to consular assistance is a mandatory clause under Vienna Convention. तो जितने members हैं Vienna Convention के, जितने भी state हैं, they have to follow this right to consular assistance if they are dealing with foreign nationals. So the Germany filed a case in ICJ against USA, stating that it has violated an obligation under Vienna Convention, and they demanded to halt the execution of Walter Lagrande. So the judgment of the ICJ found that US has violated Article 36 of Vienna Convention, and it was their responsibility and obligation to inform the foreign nationals about their consular right without any delay. But the ICJ did not ask USA to pay compensation to the Germany. Instead, ICJ asked US for reassurance that such violation will not be repeated in the future. So this case highlighted the importance of state compliance with international obligation and set a precedent that treatment of consular right is important, and thereby strengthening the legal framework for the protection of foreign nationals. So this case is very important in terms of state responsibility, that it was the responsibility of the US to inform the convicted or accused about their rights in the foreign country. So the Germany did not receive the compensation, but the US got the warning of not repeating such violation again in the future. Another significant case relating to the state responsibility under international law. So this happened in the year 2018 between the two states, Costa Rica and Nicaragua, and it was trial before the ICJ. So this case involved the territorial dispute between two countries. So what happened? Nicaragua was carrying out some construction activities like digging up of rivers, canal, which caused environmental damage to Costa Rica. And also Costa Rica alleged that and claimed that the construction activities which the Nicaragua is conducting is at the border area, and that territory is a disputed territory. So the ICJ decided on various aspects, including the environmental harm, procedural issues related to both the parties' rights in the disputed border area. And at the end, the ICJ gave decision in the favor of Costa Rica and ruled that Nicaragua must compensate Costa Rica for all the environmental damages that it has caused to Costa Rica. Next is the case of Democratic Republic of the Congo versus Uganda. This was a case which has been going on for a long time and finally concluded in the year 2022. So in this case, what happened? Uganda's alleged military incursions happened, and it was supported by armed groups operating in the Democratic Republic of Congo, DRC. So DRC accused Uganda for violating its sovereignty and international law for conducting armed activities on its territory. So to understand this in a simple manner, यहाँ पर क्या हुआ, जो युगांडा का जो मिलिट्री थी, नॉट एग्जैक्टली मिलिट्री बट अलिज्ड जो मिलिट्री थी, वो सपोर्ट करी थी एक आर्म्ड ग्रुप को. कहाँ पर? डेमोक्रेटिक रिपब्लिक ऑफ कॉन्गो में. So this support was resulting in internal conflict in DRC. So DRC approached ICJ claiming that because of Uganda's military support and incursion, they are facing various internal conflict and damages. So ICJ issued its judgment addressing the legality of Uganda's action and also the consequences for violating the international law of sovereignty and territorial integrity. And ICJ also ruled in favor of DRC and asked the Uganda to compensate DRC for all the damage that it has caused to the country. And in total, the Uganda was asked to give $350 million to DRC for all the damages that it has caused. So there are some draft code available for state responsibility under international law, and it was drafted by the International Law Commission. So it is the responsibility of states for internationally wrongful acts 2001. So under this, the background is to codify the principle for state responsibility for internationally wrongful act. So this was the main objective and also the purpose, to have certain principle to clarify what should be there and what should happen in case of wrongful act done by states. So the content of this draft code, the code outlines rules regarding attribution of conduct of states, breaches of international obligations, and also the consequences and forms of reparation for wrongful conducts. These are all the things that we have already studied, that this draft deals with these things relating to state responsibility. Now, purpose of this draft code: it serves as a guideline for determining when a state is responsible for its action under international law and how injured states or individual can seek redressal or remedy. So this is the draft code for the state responsibility, which was drafted by International Law Commission. Next is the rule of exhaustion of local remedies. So also this rule comes into the picture under international law while dealing with the state responsibility. So this rule says that only a state should bring a claim to at international platform when they have exhausted the local remedy. मतलब उनके पास जो डोमेस्टिक लीगल सिस्टम में जो रेमेडी है किसी इशू को हैंडल करने की अगेंस्ट स्टेट, अगर वो नहीं है, अनअवेलेबल है, इनइफेक्टिव है या फिर एग्जॉस्ट हो गया है, मतलब अब और कोई रास्ता नहीं है, then only they should approach international platform to bring such claim. So this is the rule of exhaustion of local remedies. Now let's look at the definition. The rule requires that before a state can bring an international claim against another state for a wrongful act, it must first exhaust all available domestic remedies. जितने भी domestically and nationally remedies available हैं, पहले वो use करेंगे, फिर हम लोग international claim पर जाएंगे. This is the rule of local remedies. Next is purpose. क्या है अब इस रूल का? This rule promotes respect for sovereignty of state, non-intervention, and also allows domestic legal system to address the issue before going to the international dispute, and also to discourage so many international level disputes. एक्सेप्शन क्या है कि अगर डोमेस्टिक रेमेडी उस मैटर पे अवेलेबल ही नहीं है या फिर इनइफेक्टिव है, तो इन सब केसेस में जो कंट्रीज हैं उनको डायरेक्ट इंटरनेशनल प्लेटफॉर्म अप्रोच करना चाहिए. सो दिस इज द रूल ऑफ एग्जॉस्शन ऑफ लोकल रेमेडीज. That was all in your state responsibility unit. So under this a question may come: what are the responsibility of a state under international law? So you have to start with the meaning, that what is state responsibility. Then you have to start with the elements, that is attribution of conduct, breach of obligation, and next is preclusion of wrongfulness. Then you have to start with the remedies, that is reparations. Then you have to include the cases as well. Then you have to talk about International Law Commission's code, and also you can include the rule of exhaustion of local remedies. So these are some of the subheadings that you should have in your answer. And also please include cases, because cases makes your answer more authentic and more presentable, because law is not only theory, it should be backed by evidences, and such judicial pronouncements helps us with evidences. So all the best for unit 4.